All right, good morning, everybody. We're ready to go?
Yes, we are ready at the jail.
All right, folks. All right. First is Fultz, and then on deck is Brown. This is a child abuse. Scores a 7. What does the state feel is appropriate?
Thank you, Your Honor. Your Honor, the state's requesting $15,000 bail with no 10% cash option, DAS with daily testing if she posts. Ms. Fultz scores a 7 on the risk assessment. However, she just pled no contest to possession of a controlled substance, 42 to 100 grams of meth, on November 18th, and she has sentencing set on January 8th. She had multiple violations while on pretrial supervision, including positive and missed tests, an arrest out of Carson City, and then this arrest. She also has in 2024 misdemeanor arrest for contempt on October 14th, and then a misdemeanor arrest for contempt on April 4th. And then in 2023, she's got a felony arrest for possession of controlled substance, 14 to 28 grams out of Carson City with no disposition. So, Your Honor, clearly she's not going to comply with conditions. She's on pretrial supervision right now in her felony case with sentencing set. The stakes honestly couldn't be higher. Now the state's going to be free to argue in that case. So for those reasons, the state is requesting the $15,000 bail with the no 10% cash option and DAS with daily testing if she posts.
All right, Beth.
Thank you.
Can you hear me?
Ms. Fultz is unable to afford any amount of money bail. Regarding the charges in this case, her children have been placed in the protective custody of Human Services Agency. There's a hearing on Friday the 3rd regarding that ongoing custody. Because the children are no longer in the home and she will be needing to comply with the conditions imposed by the family court. In addition to these conditions, we would ask for an own recognizance, understanding that she does have the sentencing coming up, and as the state indicated, the stakes are very high for her to appear for all of her future court appearances, both in this court, the district court, and in family court.
All right. Well, unfortunately, the state has shown by clear and convincing evidence that bail is necessary. Well, the defendant's recent behavior has shown that bail is necessary to ensure the safety of the community and the appearance of the defendant. Therefore, we set at $15,000, random drug and alcohol testing, DAS supervisional bail laws, make all court appearances, comply with CPS. I will allow her to be OR'd either through IAP, residential, if for some reason that district court gets continued out, or if district court sentences defendant to probation. So 3 ways out: post your bail, go to residential treatment, or if you're able to convince district court to give you a chance on probation, then you get out. Otherwise, we'll see you January 8th at 9 a.m. for your arraignment. Brown and then Tori.
And Your Honor, we would ask to waive Mr. Brown's appearance.
All right. What is the state feels appropriate for bail?
The state's requesting for Mr. Brown $15,000 in DAS with testing. He previously scored a 6. This is an ad book. He pled guilty yesterday to possession of drug paraphernalia. He's also got that PMP hold. In, 2018, he's got a felony arrest for parole violation and then a felony conviction for sex offender failure to register. And then in 2000, he's got that underlying offense. He was sentenced to life with parole in that case. And then he's got a misdemeanor conviction for failure to register back in 2000, then additional older misdemeanors and a felony conviction for PCS in 1988 and a felony conviction for sales of a controlled substance in 1990. The issue, Your Honor, is obviously Mr. Brown admitted that he hadn't registered because he was on the run from PNP, presumably from the supervision that stems from that underlying conviction. So obviously he's a flight risk. Obviously he's a risk of continued criminal conduct. So the state is requesting that $15,000 bail.
All right. Defense.
Your Honor, we'll submit on the bail this morning.
All right. I do find by clear and convincing evidence that bail is necessary to ensure the safety of the community and appearance of the defendant will be set as requested. $15,000 DAS supervision obey all laws, make all court appearances.
Behavior in this case is disgusting.
Tori and then Smith. We do have a victim here on Tori, I believe. Domestic battery, strangulation, prevent, dissuading, false imprisonment, battery with a deadly weapon, domestic battery first, scores of 3. What does the state feels appropriate?
Thank you, Your Honor. So I would just note first, Your Honor, based on the facts that I see here, I won't be charging the battery with a deadly weapon. So the bail I'm requesting,
Woo, I just wanted to do a test and I picked an ugly call at random.
the 10%, the no 10% cash option doesn't apply unless Your Honor feels otherwise. But the state is requesting $3,000 bail, no contact with the victim, no firearms, and that is all. I know, so that Your Honor did indicate the victim is present. She did indicate to my office that she would be present. She told us that she doesn't want a no contact order, and she's not afraid of the defendant. But the issue I see with that is that on the danger assessment, she marked yes to all of the questions. And then specifically for has the defendant tried to kill you, she says 1 year ago after breakup, talked about slamming the car into the tree and slicing me with a sword. And then has he ever threatened to kill you? And she marked every day. And so there's this discrepancy that's frankly very concerning to the state, given the facts of this case, the multiple instances of choking that are alleged here. And so for those reasons, the state is requesting the $3,000 bail.
There's only one thing to say here.
That's
And you know what it is.
We will be requesting an own recognizance release, even if the victim is not requesting a no contact order. The court could certainly impose that as a way to mitigate concerns for her safety and ongoing concerns. We were able to speak with Mr. Tori's father, who is also a witness and indicated in the probable cause and an attached witness statement. Mr. Tori lives with his parents and would return to that residence.
Which is number one,
supported
wrong.
by the family and does some additional odd jobs, confirmed his phone number and has family support to make sure that he attends all future court appearances. He has not been in trouble before, so there's no indication he would fail to comply with any conditions or miss, future court appearances. I don't have all of the details, but Mr. Tori's father indicated that he had left some things out of his initial statement and was following up with officers to supplement the report that he had given. So we would submit that the state has not met its burden by clear and convincing evidence that there are no less restrictive options.
Oh. No. Allow me to retort.
Behavior in this case is disgusting.
Than to impose money bail for Mr. Tori.
all right.
And Your
Ms.
Honor,
Davis-
the victim would
Go
like
ahead.
to speak to
Yeah.
the court.
Ms. Davis, go ahead and unmute yourself and you can tell me whatever it is you want to tell me.
I just want to say I love him a lot and he's not a bad person. Our relationship is just somewhat toxic, but he's not a bad person. I just want to say, please don't let this define him as a human being.
Our relationship is toxic, just a skosh, just a little bit. It's not over the top toxic.
I promise he is such a kind man with a good soul and he loves me dearly. It's just, we argue a lot and his anger in our relationship hasn't been the best the past few months, but I promise you, his anger just got the best of him that day. He would never hurt me this bad. And I know that if he got out, he wouldn't do it again. But I really don't want a no contact order because I do love him and I don't want to stop talking to him. That's all I have to say. Thank you.
Oh no.
So, ma'am,
Oh no, it has to be done. Let me find it. I'm dealing with one hand tied behind my back here, people. But you know what needs to be done. You know what needs to be done.
Exciting and new.
I have a few questions for you.
That's fine.
Does he own a gun?
Huh?
Does he own a gun?
It's fake. It's not
So,
real.
yes.
I would say, if you want to say it like that, yeah, but it's not real.
And Your
Has
Honor,
he
if I may,
ever-
just on that point,
It's
on
like
his
a-
criminal, on his
Sorry.
criminal history, he did apply, he did a background check to get a firearm and was denied.
It's like a fake
And-
gun with the orange tip.
Okay. This strangulation choking has occurred before.
What'd you say? Sorry, I cut out.
I said the strangulation choking has occurred before.
Sexually wise, yes, that's when I consent, but he's choked me before
Oh,
once, literally
no.
only one time in an argument.
I mean,
And I understand your difficult position. You love him. I just have a difficult decision to make.
like
too.
we
So-
know that, but don't say it in court. Like, yes, it's occurred, Judge, but he's always respected my safe word. That's oh, sweet Jesus! Just say no. Just say no. Just interpret that as non-aggressive. Okay? Oh no.
No, I get it. I get it.
Right. I just need, that's why I'm trying to go over the answers to these questions that the prosecutor mentioned that you answered yes to. So you're not saying that you checked those yes boxes.
We're not talking about the times we did it for funsies, okay? Oh, good Lord.
by mistake. You're just saying you love him, you think he's a good person, and that doesn't define this.
Yeah, it doesn't. It's just we're very toxic. I've been with him since I was 15. So he's had to deal with childish me and he's had to deal with mature me. And then yesterday we didn't sleep. We were up all night playing the game. So he was running off with no sleep, and then I was pissing him off, and it got way out of hand. And it shouldn't have. And part of that is my fault too. I'm not defending him or anything. I'm just saying he's not a bad person. He's a good man with a kind heart. His anger just gets the best of him, and I tell him he needs to get that in check.
I understand. Well, I want to thank you for being here. I want to wish you the best of luck in the future.
Thank
With
you.
regard to the decision I'm presented with, it's a difficult one. I will say I'm not going to set the bail that the state requested because I think the defendant's going to make it. And I believe you're in or you're out because there's no evidence that posting money bail does anything to ensure the safety of the community or the appearance of the defendant. Something we're going to have to address that we've addressed in the DUI cases with the use of the DUI RAND is the danger assessment. And some people know, anyone involved in when we got the NPRA, that I
No, it was a sausage.
had indicated that this is what we needed. We needed a specific violence predictor or danger assessment on these types of crimes. It's something that many of the pretrial tools have built into them, like the PSA court, and ours doesn't. And generally, the violence predictor is accurate in the validation studies of the pretrial tools that use it. There are some domestic violence assessment.
Again, I imagine the violence predictor as like the 8-ball. Everything's the 8-ball. Do you see future violence? Very likely.
Tools that frankly the evidence is inconclusive. But
For you youngsters,
the
just
questions
forget
that
it.
are on this danger assessment are for the most part the same that are on the violence predictor of the PSA court. So I'm presented with a standard risk assessment of whether he's likely to show up, and it looks like he's likely to show up according to the NPRA. Then whether he's likely to reoffend and whether he's likely to engage in violent, dangerous behavior, especially towards this victim. And if 11 out of 11 answers are yes, there's not a higher risk that danger assessment can contemplate. So I'm faced with a tool that says he's a great danger to harm this victim. And I have the victim who's in love with him that says that he's not, but the evidence says that he is. And unfortunately, we know in domestic violence cases, somewhat like DUI cases, that the crime occurs again and again and again before an individual is arrested. We don't have the arrest on this circumstance, but we do have the evidence in the sworn probable cause sheet and in the danger assessment that is consistent with that. So that's a long way of me saying that, unfortunately, and I do say unfortunate in this case and the previous case, because I think the majority of the people should be out. I think I'm constitutionally compelled. That's our system, and we over incarcerate folks, especially when they're presumed innocent. But how do I have a danger assessment that says 11 out of 11, highest danger assessment possible, and release somebody on their own recognizance or on a nominal $500 bail, the cash that they could post? And so, unfortunately, I will say again, I have to set bail at a high amount because the state has shown through the evidence presented, including the danger assessment, that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and appearance of the defendant. So we set it at $50,000, no contact with the victim, separate criminal offense pursuant to NRS 178-445 for the maximum 120 days, ankle bracelet in place before release to ensure compliance, no firearms, checking with DA's order, bail laws, make all court appearances, January 8th at 9 a.m. for the arraignment on the criminal complaint. Smith.
I can talk to him if you. Your Honor, Mr. Smith was ill today, we believe, detoxing. If we could continue him to tomorrow.
Wow, well, there you have it. How's the sound level? I'm looking. That literally, I looked at it. It was a 15-minute clip. I like Elsa. She's cool. She always makes sense. So I thought, whatever, I'll just do a test. I didn't realize that clip would be that. I would have picked the clip had I seen it before, but I didn't. Oh my Lord, that was something. By the way, I'm not suggesting she should do that. I made my little joke. It's a good thing his bond is high and that he's probably not going to get out for a little bit here to calm down. I do think he's a danger. I'm not saying that. What was making me laugh is in her mind, she was trying to spring him out of jail. That was her idea. I love him. I think he's a good man. I don't want him in jail. Okay. If that's your goal, she was not saying the right things. I'm not saying it should be her goal. I'm saying since it apparently was her goal, she was failing miserable at her aim. Hence the humor. There you have it. I'm sure I'll still get pearl clutchers. The pearl clutchers are coming. They always are. They always are. What do you think? What do you think of my generic kitchen background for my Airbnb? Is that good? Or do I need to spruce that up a little bit? All right, I'll stop. Thank you. Successful test. Thank y'all for coming out. I appreciate it.